Good morning everyone, my name is Michelle, I hope you're doing well. Welcome to another video. It is Tuesday morning the 8th of October. And before we get into today's video, I just want to let you know that Sarah Boone's trial has been continued until next week because of Hurricane Milton. So she's got a short continuance. Jury selection will start next Monday the 14th. Interestingly, however, Sarah was offered a very generous plea deal by the state. So the trial could have been avoided, but no, not our Sarah. No, she knows better. Suitcase Sarah rejected the offer of 15 years if she pled guilty to manslaughter. Now, bear in mind, she's already served 4.5 years, so that's time served. And if she kept her nose clean, she would be able to get parole way before the 15 years was up. So, arguably, she may only have needed to serve another maybe 4 or 5 years behind bars. But no, she wants to clear her name completely because she knows better. But if the jury find her guilty, she will serve a minimum of 22.5 years. A minimum. So what can you do? You can lead a horse to water, but you can't make him drink. In today's video, we are going to be talking about the Delphi case. Richard Allen's wife, Cassie, has spoken out, and Richard Allen's defence team have got spicy with one of their responses to a ridiculous motion in limine, which was posted by the state a few days ago. So, let's get into it. Take it away, Andy.
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Let's start with the statement by Cassie Allen. So she's been very quiet. She hasn't spoken publicly at all during the last 2 years of her husband's very unfair incarceration in state prisons. She has been so gracious, and I don't know if I could have held my tongue for this long. And the statement that she's put out is as gracious as her behaviour has been over the last 2 years. So it was prompted by the murder sheet contacting Cassie. So the following is in response to questions directed to Cassie Allen. My name is Dave Cloutier. I've been a licensed attorney in Indiana for over 28 years, practicing in South Bend, handling personal injury and wrongful death cases, primarily in north central Indiana. I can confirm I am privileged to represent Cassie on a pro bono basis with respect to advising her about protecting her interests related to the publicity surrounding the State versus Allen case, in which Cassie's husband Rick is accused of the tragic murders of Liberty German and Abigail Williams. Cassie and I were brought together by a mutual acquaintance who, as a professional, felt strongly that Cassie needed advice and representation for herself. Over the several months, I've gotten to know Cassie very well. She is under incredible stress and has handled it with grace, dignity and goodwill. It has been a privilege to get to know someone with Cassie's strength. She's immense. After the trial's over, what will she say? Will she speak out? There'll be loads and loads of people wanting Cassie to speak. She'll be free to, if she would like to. Cassie and I both have complete sympathy for the family of Libby and Abby and for all the people of the Delphi area. It's difficult to imagine how hard it must be for the families who deal with this loss and the unspeakable nature of what happened to Libby and Abby. For various reasons, Cassie has scrupulously avoided public comment of any kind. even in the face of repeated false claims and misinformation, both generally and specifically, related to her. Cassie has no desire to do or say anything to prejudice any party's rights related to the upcoming trial. She has also been very careful to avoid doing or saying anything to add any pain or anxiety to the families of Abby and Libby. However, recently, Cassie was contacted by the Murder Sheet, from who she learned of a claim by an unknown person or persons about Cassie's marriage. We appreciate the professionalism and journalistic integrity of the Murder Sheet in seeking comment before reporting. They haven't always been bastions of integrity, in my opinion, but okay. And responding on Cassie's behalf. We do so in part because the allegation brought to Cassie's attention does not relate to the facts of the case or the upcoming trial, but is specifically about her. In addition, Cassie's response is necessary because the truth matters and misinformation causes harm to her and her family. As very wisely said by Kelsey German in July of 2019, rumours suck and they hurt people. Therefore, I can confirm the following answer from Cassie to the questions you asked. So, to the Murder Sheet. Okay, so this is the question. Did Cassie consider her marriage to Rick be over and now believes his alleged confession? Relatedly, it was asked of Cassie whether she had some kind of recent change of heart and is on that basis going around saying these things. The rumours were that Cassie was going around telling people that her marriage was over and that she believed Rick's confessions, she believed he did it. Cassie's answer to these questions is most definitely and emphatically no. Cassie's marriage has certainly been profoundly affected by Rick's incarceration, and both of them are suffering immense stress. Goes without saying. Cassie loves her husband, believes in the sanctity of marriage vows, and believes that the same presumption of innocence our legal system gives to Rick should be given in equal measure by her to the husband she loves. As to her husband's alleged confessions, it's not true that Cassie now believes them, but at this time, Cassie will limit her response to just that. Finally, she has not been going around telling people these things, so it's all made up. Cassie certainly has strong opinions and much to say about these matters more broadly. Perhaps in the very near future or further down the road, she may be willing and able to say more. For the time being, she is only responding to the direct questions asked that do not relate to the facts of the case, but do relate to Cassie herself and her reputation. With malice towards no one, Cassie prays for the justice and for healing of all innocent people affected by the murders of Abby and Libby. She's also extremely grateful to Rick's defence team of lawyers, their staff and their investigators. They have been courteous and kind to her and very conscientious about representing her husband. No shit, they have been immense. And this response to the state's motion in limine about excluding the testimony of one of the defence's witnesses, William A. Tobin, is a fantastic example of that. I love the spice. It's subtle, but it's spicy. Let's read this. It's only short. Defendant's response to state's motion in limine regarding defence witness. Comes now the defendant, Richard Allen, by counsel Bradley A. Rosie, and respectfully requests that this court deny the state's motion in limine regarding defence witness filed marked September 27th, 2024. In response to said request, defendant Allen states the following. 1. The state's motion seeks to exclude the testimony of William A. Tobin. In a previous video, we had a look at William Tobin's experience and his expertise. There's absolutely no reason that his testimony should be denied from the trial. But this, as Brad Rosie is so good at doing, is creating a record for any possible appeal down the road. Mr. Tobin is a 27-year veteran of the FBI, with 24 years of experience at the FBI lab and an expert in forensic metallurgy. Who knows? Indiana Rules of Evidence 702 provides that an individual may be qualified as an expert and testify to matters so long as it helps the trier of fact, i.e. the jury, to understand the evidence or to determine a fact at issue. Mr. Tobin's expertise and testimony will assist the trier of fact in judging the credibility of the processes and protocol used in the discipline of firearms identification for the following reasons. Mr. Tobin has a bachelor's degree in metallurgy, a hard science that is intimately connected with the process of tool mark identification, the study of various metals, how they act, etc. Mr. Tobin has an academic background in statistics, which is also pertinent to the process through which firearm examiners draw their conclusions. Mr. Tobin was previously employed by the FBI for 27 years, having worked in the FBI lab as an expert in forensic metallurgy for 24 years. Forensic metallurgy is an expertise that is part and parcel to the skill of tool mark identification. Mr. Tobin has testified as an expert witness on more than 200 occasions in courtrooms throughout the United States. Mr. Tobin's work and opinions were recently cited in the case of Abrukwa versus State. The High Court in Maryland ultimately vacated Abrukwa's conviction and remanded the case for a new trial. The court's decision was driven in part by the defence's assertion that the underlying process of firearm identification is flawed, all of which was supported by Mr. Tobin's testimony. Well, this is why Nick doesn't want this guy to testify. He knows this full well. And if the jury loses faith in the magic bullet that was found at the crime scene belonging to Richard Allen's Sig Sauer P226, well, it's a massive arm of the prosecution's case. If the jury have no faith in that, there's absolutely nothing, no DNA, fingerprints, anything that ties Richard Allen to that crime scene. No phone records, nothing except the magic bullet. If the jury has no faith in the quote-unquote science that matched that unspent round to Richard Allen's weapon, the jury has nothing. The jury has nothing whatsoever to tie Richard Allen to that crime scene. This is why the 61 confessions by Richard Allen are such a big deal for the state. But we don't know what the nature of those 61 confessions are. Are they merely the babblings of an insane man, driven into psychosis by his treatment at Westville? That's something we need to wait and see on. The state's examiner, Melissa Oberg, is nothing more than a lab technician. Oh, burn! Oh dear. While she has received training in the discipline of firearms examination, anyone with a high school degree could do the same. This is much like what happened in the Karen Reid trial. The state's witness about the vehicle and the speed at which the vehicle was going, and the fact that her vehicle was supposedly the quote-unquote murder weapon. And the defence put on these experts from the FBI, and yeah, it was great, but it's a very similar situation to this. The state of Indiana references Dr. Eric Warren, who is an expert in firearms identification. So Eric Warren is another one of the defence witnesses. Dr. Warren has been retained by the defence in this case. The state, in its motion in limine, attempts to compare Dr. Warren's expertise to that of Miss Oberg by pointing out the two of them are both members of AFTI. The comparison stops here. Dr. Warren has a PhD in biological sciences and is a current AFTI board member. So not just a member, he's a board member. The state took Dr. Warren's deposition on October the 3rd, 2024, so just a few days ago. During Dr. Warren's deposition, Dr. Warren acknowledged that an academic background in metallurgy, a hard science, would be helpful in understanding the process of firearms identification. So exactly what William Tobin is an expert in. Dr. Warren testified that a background in statistics would be helpful in understanding the process of firearm identification, specifically noting that he anticipates changes and advances in the field which will be driven by new statistical approaches to summarising the findings of any particular examination. Well, that will be an interesting, very interesting advancement. You know, these two guys, Dr. Warren and William Tobin, are at the forefront of this scientific change. Dr. Warren testified that the critical community within which Mr. Tobin associates has been helpful in moving the firearms identification forward by pushing for new and better processes. Absolutely. As science advances, so should the understanding of that science and the application of that science in the courtroom. But obviously, for this trial, that's something that Nick McLeland needs to avoid. Finally, Dr. Warren testified that there does exist a healthy debate in the industry as to whether or not the findings of firearms examiners should be inadmissible in courtrooms across this country. In fact, there is a movement towards examiners being less definitive about their conclusions in courtroom settings. Again, that's something that Nick wants to avoid any discussion about in this trial. Mr. Tobin's testimony is relevant for the following reasons. The President's Council for Advisors on Science and Technology, PCAST, has been critical for many years of the methodology employed by toolmark examiners across the country. And it's not just about the toolmark examination, it's about the examination of an unspent round. The science is even more controversial on unspent rounds than it is for spent rounds. The National Academy of Sciences, NAS, has issued two reports, one in 2008 and one in 2009, that have been critical in part of the accreditation, certification and lack of independence of labs conducting firearms examinations. Mr. Tobin is intimately familiar with the findings and work of both PCAST and the NAS as it relates to the discipline of firearms identification. The concept of understanding a process which generates any result, whether it be in the lab setting or in the course of one's daily activities, is relevant to understanding the meaning of the result or final product created by the employed process. Simply put, Mr. Tobin's testimony tends to prove that the process of examining firearms and drawing conclusions from those examinations is unreliable and misleading. Therefore, the conclusions offered up by the state examiner should be given little to no weight, and it's up to the jury to determine how much weight the finders of fact give the science and the interpretation of the unspent round, i.e. the magic bullet. Mr. Tobin's opinion on these matters is relevant to the credibility of the state's lab technician who examined the evidence in this case. Finally, the state cites the case of the state of Indiana versus Caden Smith. This is a trial court case out of Marion County, Indiana, which is currently up on appeal. The court's order in Smith provides very little rationale for the court's decision to exclude Mr. Tobin's testimony regarding the firearms examination process, to the extent the state wants to offer up trial court level authority to support its claim. Defendant Allen would draw the court's attention to the case of People of the State of Illinois versus Ricky Winfield, a circuit court case out of Cook County, Illinois. The Winfield decision was handed down on February 8, 2023. The court in Winfield was critical of the discipline of firearms identification altogether. The court ultimately drew the conclusion that the state was entirely prohibited from introducing any testimony from their alleged experts regarding firearms identification specific to the case. Judge Hook's rationale was articulated in a 41-page opinion. The Smith case offered up by the state contains no such analysis. Smith case is currently up on appeal, and I'm quite sure that one of the reasons for the appeal is because an expert's testimony, i.e. Mr. Tobin's, was excluded. So it's not even a settled case. Nick. It is for these reasons that the court should deny the state's motion in limine regarding Mr. Tobin's testimony. Respectfully submitted, Bradley A. Rosie. Look, if Francis excludes the testimony of William Tobin, it's yet another example of how biased she is and how desperately she's trying to support the state in any way she can. For that reason, the scales of justice in Francis Gull's hands are very, very tipped in one direction when they should be held constant and in balance. But let me know your thoughts in the comments, and I'll see you in the next video. Bye, guys.